Thank you. Order. Statement, the Secretary of State for Culture, Media and Sport. Secretary Karen Bradley.
Mr. Speaker, with your permission, I wish to make a statement on matters relating to the Leveson inquiry. A free press is an essential component of a fully functioning democracy, which is why it was a manifesto commitment of this government to defend a free press. The press should tell the truth without fear or favour and should hold the powerful to account. However, that freedom has, in the past, we now know, been abused. Mr. Speaker, we know that some parts of the press have ignored both their own code of practice and the law. I have met victims of illegal and improper press intrusion, some of whom have suffered immense distress. In July 2011, the Coalition Government announced an inquiry into the role of the press and the police in phone hacking and other illegal practices in the British press. Lord Justice, now Sir Brian Leveson, was appointed chair of the inquiry. Part 1 of the inquiry examined the culture, practices and ethics of the press. It considered such matters as whether the press needed a different form of regulation and how the press interacted with the public, the police and politicians. Sir Brian Leveson heard evidence from more than 300 people, including some of those who had been affected by the most atrocious press behaviour. On 29 November 2012, the Leveson inquiry published its report on Part 1. It contained 92 recommendations, the majority of which have been acted upon and are being delivered. Part 2 of the inquiry, which has not yet begun, would further examine wrongdoing in the press and the police. Mr. Speaker, following a cross-party agreement, a Royal Charter established the Press Recognition Panel, which began operating in November 2014. As stated on its website, the panel's purpose is to ensure that any press self-regulator is independent, properly funded and able to protect the public while recognising the important role carried out by the press. Since September 2015, the panel has been taking applications from regulators who are seeking recognition. Alongside the Royal Charter, Section 40 of the Crime and Courts Act 2013 was designed to incentivise newspapers to join a recognised self-regulator. Section 40 has passed into law but remains uncommenced. This is one of two incentives. The other, relating to exemplary damages, came into effect on 3 November 2015. A self-regulator applying for recognition must meet the specific criteria set out in the Royal Charter, including providing a system of low-cost arbitration that replaces the need for court action. Section 40 contains two presumptions. One, that if a publisher who is a member of a recognised self-regulator loses a relevant media case in court, they do not have to pay the winning side's costs. And two, that if a publisher who is not a member of a recognised self-regulator wins such a case in court, they would have to pay the losing side's costs as well as their own. Each element was intended to encourage the press to join a recognised self-regulator through a legitimate rebalancing of normal rules on costs. Mr. Speaker, it has hitherto been the view of Government that as we wait for a number of elements of this new self-regulatory regime to settle in, such as the exemplary damages provision of the Crime and Courts Act, the press developing an effective form of voluntary self-regulation and self-regulators applying for recognition, the time has not yet been right to commence Section 40. However, the panel has recently recognised its first self-regulator, the Independent Monitor for the Press, known as Impress, which currently has around 50 members. Meanwhile, the Independent Press Standards Organisation, known as IPSO, regulates more than 2,500 publications, but has been clear that it will not seek recognition from the panel. We think the time is right to consider Section 40 further. It has also become apparent that the final criminal case relating to the Leveson inquiry is entering its final stages. We therefore think this is also an appropriate time to start to consider next steps on Part 2 of the inquiry. Many of the issues that Part 2 would have covered have been addressed in the last 5 years. 3 police investigations, Operation Elvedon, Tuleta and Weeting, have investigated a wide range of offences. A clear message has been sent to all police officers and public officials that receiving payments for confidential information will not be tolerated and will be dealt with robustly. The Metropolitan Police Service has introduced new policies on whistleblowing, gifts and hospitality and media relations. Mr Speaker, there was also a degree of subject matter overlap between Parts 1 and 2 of the Leveson inquiry. For example, the inquiry reviewed the MPS's initial investigation into phone hacking and the role of politicians and public servants regarding any failure to investigate wrongdoing in News International. Part 1 made numerous recommendations, all of which are being addressed by the police, Her Majesty's Inspectorate of Constabulary, the Independent Police Complaints Commission and the College of Policing, where they relate to them. Given the extent of these criminal investigations, the implementation of the recommendations from Part 1 of the Leveson inquiry and the cost to the taxpayer of the investigations in Part 1, which is £43.7 million and £5.4 million respectively, the Government is considering whether undertaking Part 2 is still in the public interest. We are keen to take stock and seek the views of the public and interested parties, not least those who have been victims of press abuse. We will also formally consult Sir Brian Leveson on the question of Part 2 at the appropriate time in his role as Inquiry Chair. I can announce, Mr Speaker, that today we are launching a public consultation, inviting comments on both Section 40 and Part 2 of the Leveson inquiry from organisations that are affected by it and from the public. It will run for 10 weeks from today, 1st of November, until the 10th of January 2017. This is laid out in a consultation document entitled Consultation on the Leveson Inquiry and its Implementation, published on gov.uk. I am also depositing it in the libraries of both houses. Mr Speaker, I have met Sir Brian Leveson and spoke to him again this morning. I will write to him formally as well. I am extremely grateful for all the work that he and his team have done to get us this far. The Government is determined that a balance is struck between press freedom and the freedom of the individual. Those who are treated improperly must have redress. Likewise, politicians must not seek to muzzle the press or prevent it doing legitimate work, such as holding us to account. And the police must take seriously its role in protecting not only its reputation, but also those people it is meant to serve. This is the balance that we wish to strike, and this consultation is the most appropriate and fairest way of doing so. I commend this statement to the House.
Yeah. Tom Watson. Yeah.
Mr Speaker, what a sad day this is. Yeah. At least I'm grateful to the Secretary of State for giving me an advance copy of her statement an hour ago. 947 days after all parties reached an agreement on the recommendations of the Leveson inquiry in full. The Prime Minister herself set the test for this process on the 14th of June 2012, when she said to the inquiry, "I will never forget meeting with the Dowler family in Downing Street to run through the terms of this inquiry with them and to hear what they had been through and how it had redoubled, trebled the pain and agony they've been through over losing Millie." And she went on to say that the test should be, are we really protecting people who've been caught up and absolutely thrown to the wolves by this process? That's what the test is. And the Government reassured victims that if they spoke out at Leveson, they would act on his recommendations. Well, today, Mr Speaker, the Culture Secretary has announced we must wait another 10 weeks while those reforms are discussed all over again in the context of a wider consultation on the press. Mr Speaker, we on this side of the House believe that they've been discussed and debated enough. Yeah. They should have been implemented years ago. The victims of press intrusion cannot wait a day longer for this Government to honour David Cameron's promises to pass Theresa May's self-defined test. For the Culture Secretary to stand here today and announce a consultation into the press nearly 1,000 days after those reforms were agreed by party leaders is deeply regrettable. As she said, it is over 5 years since the last Prime Minister stood at the dispatch box and announced an inquiry into press practices and ethics. A lot has happened since then. We've had the Hillsborough inquiry and its findings on misleading police statements to government officials and subsequently newspapers. We've had the debate on Orgreave just this morning. We've had the case of Mazza Mahmood, the fake sheikh who perverted the course of justice to secure his scoops and in so doing left scores of previous convictions unsafe. We've had senior police officers have to resign over phone hacking. We've had more information emerge about the brutal murder of Daniel Morgan, a private investigator who was threatening to reveal police corruption to the press. We've had over 30 police or public officials jailed for bribery. Leveson too was meant to look at the relationship that existed between newspapers and police, and despite the exposure of criminality, it is impossible for the Minister to credibly conclude that we've learnt enough about the corruption to halt Leveson 2 before it starts. One of the terms of reference of the second part of Leveson is, after all, to inquire into the extent of the corporate governance and management failures at News International and other newspaper organisations, and the role, if any, of politicians, public servants and others in relation to any failure to investigate wrongdoing. In other words, Leveson's Part 2 is the investigation into how the cover-up of phone hacking was conducted. In effect, she is today announcing a consultation on whether the cover-up should be covered up. And it's my view that the events of the past 5 years make Leveson 2 more urgent, not less. Let's remind ourselves why Leveson was established. It was to allow an independent inquiry to draw conclusions free from influence of vested interests and political interference. Leveson was created so that a minister would not have to worry what pressure she was put under by newspaper editors. And what she's doing today is abandoning that principle. She's taking back the power from an independent judge, and in so doing, she opens up the executive to accusations that they have succumbed to the vested interests of media barons. I'm afraid it's an age-old story, and she is carrying the can. And so I'm afraid she leaves us no choice but to ask her some searching questions. Firstly, did the Prime Minister discuss the Leveson process at a private meeting with Rupert Murdoch in New York last month? Secondly, when she spoke to Lord Leveson earlier today, did he approve this hurried consultation? Does he agree with her analysis? Will she allow him to make a public statement? Finally, has she spoken to the parents of Millie Dowler and the other victims of press intrusion? What is their view of these proposals? Do they think it passes the Prime Minister's test? Are we really protecting the people who've been caught up and absolutely thrown to the wolves?
Yeah. Mr. Speaker, I welcome the honourable gentleman to the dispatch box, but I'm afraid I disagree with much of what he has just said. If I can start by being clear about victims of press intrusion. The first people I met in this job regarding press regulation were the victims of phone hacking with Hacked Off. And I have been determined throughout my time to make sure I do meet as many victims as possible. It's something I did in my previous role in the Home Office, and it's something I continue to do. Because if we don't listen to people and what they've been through, we cannot possibly imagine and legislate in an appropriate way. But what's clear to me, and I think to him, is that what we all want is effective, robust press regulation. And therefore we have to look at the situation that we find ourselves in today, not 5 years ago, to make sure we can. And he set out, actually, in his list of things that have happened, all the reasons why we need to take a step back and we need to consider the position. So I invite responses from all interested bodies, from all people affected by this. I am sure that we will get many, many responses to the consultation, and I welcome them. But we need to look at this in the situation we have today, with the press regulation that we have today, to make sure we get that right, appropriate, robust, effective press regulation, so that we can do, as he said, all we really can to protect people.
Sir John Whittingdale.
Thank you, Mr. Speaker. I welcome my right honourable friend's intention to continue to listen very carefully on these matters. Will she confirm that in considering how best to proceed, she will take account of the significant deterioration in the economic health of traditional media, which has taken place even since Leveson and is still leading to the closure of titles at both national and local level? And will she bear in mind that the real media giants of today, like Facebook and Google, are outside the scope of legislation and regulation altogether?
My right honourable friend, who was my predecessor in this role, sets out very important arguments, which are things that we do need to consider. And he's quite right that actually we need to make sure this is regulation that affects the whole of the press, not just print media that's on our high streets and produced locally, but also those global players on the internet.
Nicolson.
Thank you, Mr. Speaker. As the House knows, Section 40 of the Crime and Courts Act was passed to implement the recommendations made by the Leveson inquiry. That any new regulator set up should be accredited, independent and effective. The purpose of this section, of course, is to provide cost protection for claimants, and Leveson regulated newspaper publishers. Now, Section 40 of the Crime and Courts Act extends to England and Wales only. Regulation of the print media is devolved to the Scottish Parliament, which has provided cross-party support for the UK Government's actions to implement the Royal Charter. Now, does the Secretary of State understand the difficulties that local newspapers face and recognise that the majority of the press, especially the regional press in Scotland, was not involved in the sort of malpractice which prompted the Leveson recommendations? It's important that we must balance respect for freedom of the press and the public desire high standards, accuracy and transparency. But that said, does she agree that the protection afforded by Section 40 would be available to Scottish litigants who chose to sue based in England and Wales in the event that Section 40 was enacted? In the meantime, Mr. Speaker, SNP MPs will support the House of Lords amendment to the Investigatory Powers Bill, which will introduce a new Clause 9 on the back of Clause 8, which was introduced as an SNP amendment.
Mr. Speaker, the honourable gentleman raises the issues regarding the devolution of regulation of the press. As he will know, Part 2 of Leveson will cover the whole of the United Kingdom, but Section 40, as he said, is England and Wales. I am due to speak to Fiona Hislop this afternoon to discuss exactly how we make sure that it works across the whole country. But he makes the point very strongly that many good local newspapers were not involved in any form of press abuse or intrusion, and we need to make sure that we do press regulation in a way that protects a free, vibrant local press.
Peter Bottomley.
I declare an interest. I've had 4 successful defamation actions against newspapers. Can I say to my honourable friend that having an effective, robust press is even more important than effective, robust press regulation? And if we have 2,500 newspapers, including all those, or nearly all those, represented by the Society of Editors, and we have a pretty pathetic list in Impress, most of which I don't think have a circulation of more than about 200 or 300 or 1,000, that we must not introduce Section 40, and we ought to find a way in which the IPSO people cannot have to be forced into the press regulation panel, but can actually be recognised as representing newspapers with a proper way of redress.
My right honourable friend sums up the dilemma that faces the government today, which is that we do have over 2,500 newspapers and other publications that are not and never will sign up to a recognised regulator. We have to make this work in that climate and with that situation, and I would urge all interested parties to respond to the consultation in order that we can hear all those views.
Ben Bradshaw.
Thank you, Mr. Speaker. I thought I was going to welcome the Secretary of State's statement because she actually explained in very clear detail why the incentives contained in Article 40 are absolutely essential to the Leveson recommendations which this House approved overwhelmingly in the Royal Charter and, as she said, are already in law. But and we now have a recognised regulator. But she then went on to say that rather than commencing Section 40 now, the government would just consider it further. Why doesn't she just do the right thing on behalf of the victims, commence the legislation that this House and the House of Lords have already passed, and do the right thing by the victims?
What I said is that we're going to consult. It's a 10-week consultation. It's very clearly about Part 2 of the Leveson inquiry and the commencement of Section 40. I want to hear all views in that consultation.
Vaizey.
Thank you, Mr. Speaker. I was struck by an article at the weekend in The Observer by the former editor of The Guardian, Peter Preston, who calls for Section 40 to be mothballed and also suggests the government could seek a fresh, more collegiate start. I wouldn't expect the Secretary of State to take such an extreme position as the ex-editor of The Guardian, but does she agree with me that this consultation is exactly the right way forward? It's now an opportunity to take stock of where we are, involve all interested parties and see if we can move on in a more consensual fashion.
I too read the same article as my right honourable friend, and I think I should quote here. Peter Preston says, "It doesn't make sense any longer. Blanket bitterness, stuck in a time warp. Most editors, like most politicians with a soupçon of perspective, would know what to say about such impasses. Time to dismantle the barricades, time to move on."
Farrelly.
Thank you, Mr. Speaker. The Secretary of State has a very easy way out of her dilemma, which is to name a future date for commencement of Section 40, and then she'll get plenty of movement because there'll be plenty of incentive. We've all, Mr. Speaker, been circulated by local newspapers at the behest of national newspaper owners, but would the Secretary of State agree that that lobbying only tells half the truth? Yes. Section 40 gives protection for serious journalism from the chilling effect of deep-pocketed, vexatious litigants, because such people would first have to go through a low-cost arbitration system and not to the courts. And in that sense, it protects hard-pressed local newspapers in particular, where sadly their investigations have not been of the calibre generally as we've been used to in the past.
The honourable gentleman and I discussed this at Select Committee last week, and we share the Stoke Sentinel, which communicated with both of us as our local paper. But he must recognise that Stoke Sentinel and others have signed up to IPSO. IPSO is not does not have recognition under the press recognition panel. We need to make sure we get this right. That's why we need to take stock, we need to listen to all views, and we need to consider the position based on the fact that we are now 5 years on from the original date of the inquiry.
Questions are rather long, but perhaps we can get pithiness from a classicist and a philosopher, Sir Oliver Letwin.
Thank you, Mr. Speaker, for that equivocal introduction. I welcome my right honourable friend's statement. Would she agree with me that actually the press, who are members of IPSO, could spare us a lot of grief and actually move the matter on if they were to enforce through IPSO a genuinely Leveson-compliant regime, including the provision of a low-cost arbitration service?
Mr. Speaker, can I pay tribute to my right honourable friend for the role that he had in developing the cross-party agreement, and these are exactly the kind of comments that we want to hear through the consultation.
Mr. Bryant.
I rather agree with the honourable member, the right honourable member for West Dorset, that is precisely what IPSO could do. But this is now a matter of keeping faith. And David Fuchs was killed in the July the 7th bombings at Edgware Road, and his father Graham said, "We were in a very dark place. You think it's as dark as it can get, and then you realise there's someone out there who can make it darker." The honourable member who's just spoken made promises to Mr Fuchs. The Prime Minister did. The present Prime Minister did. The member for Wantage made promises to Mr Fuchs and to so many others. First of all, that the commencement would start immediately. And secondly, no ifs, no buts, there would be Leveson too. Why on earth is she reneging on all those promises made to the victims?
Nobody is reneging on any promises. We're having a consultation. We want to hear all sides and we can make a decision after that.
Mr. Philip Davies.
Mr. Speaker, will the Secretary of State bear most in mind the weakening and poor health of local and national newspapers as set out by my right honourable friend for Malden, and make sure that they will always be protected in being able to expose people in authority and protect them from rich bullies who, by the very threat of legal action against them, may force newspapers not to print stories that would be in the public interest? Not doing that may suit many people in this House, but it would do a gross disservice to the public at large.
I think my honourable friend is right. We've all had instances where local newspapers have perhaps printed something that we perhaps didn't necessarily entirely agree with, but I defend the right for them to do so.
Julie Elliott.
Mr. Speaker, I have to say I feel so let down and disappointed by the statement that the Secretary of State has made today. She could have come and announced the commencement of Section 40, which would have been the right and proper thing to do. I don't know what she thinks more talking will do after the months and months in Leveson, but I want to ask the specific question. Has she met with the families and the victims of press regulation in the past, of the lack of press regulation, to say that more delay, more consultation was going to happen? Not on the day she took office, but today or yesterday, to say what she was coming here to announce today.
As I responded to her honourable friend on the front bench, I have met victims. I will continue to meet victims, and I'm going to make sure that I have correspondence and engagement with all. But I wanted to come to this House and make this announcement because I think that Parliament needs to hear this first.
Mr. Jacob Rees-Mogg.
Thank you, Mr. Speaker. And I suppose I'd better begin by declaring an hereditary interest rather than a direct one. I want to commend my right honourable friend's excellent statement. She is clearly right to be reviewing this because the system cannot be working where Impress, funded by a degenerate libertine who was embarrassed by free newspapers a few years ago, has only 50 subscribers, and Ipso 2,500 representing the vast swathe of the press. And she is quite right to review this, and also right to defend the freedom of the press, which is more important than the press being responsible.
Can I thank my honourable friend for his comments? This is why we're having a consultation. I want to hear all responses, and I want to look at this in the light of today, not 5, 10, 15 years ago.
Mr. Andy Burnham.
Thank you, Mr. Speaker. One of the common threads between the injustices uncovered in recent years is a unhealthy, collusive relationship between police and press. Part 2 of the Leveson inquiry was intended to examine this in detail. It's seen as essential by Hillsborough campaigners to bring a form of accountability, and yet the Secretary of State, if I heard it correctly, has effectively announced today she's consulting on a decision to reject it. Can she not see that this will leave campaigners feeling bitterly let down? And doesn't it sound for all the world, like the second government cover-up in just 2 days?
I agree with the right honourable gentleman, who I have enormous respect for. But in this case, he's simply wrong. We are consulting as to what is the right thing to do today. But he must recognise that there have been significant changes in terms of the way that the police behave and the way that they're accountable, and much of which was uncovered during the inquiry on Hillsborough. I want to look at the position today to get the right result for those that have been victims in the past of press intrusion, and to make sure that those people in the future have the appropriate regulation and appropriate redress.
Mr. William Wiggin.
Thank you, Mr. Speaker. I really welcome the comments my right honourable friend made about effective and robust regulation. It is crystal clear that Ipso does neither of these, and will she do all she can to ensure that low-cost arbitration is on the top of her list?
The point my honourable friend makes is an important one. We do want to see all people, no matter what their background, being able to get appropriate redress and arbitration that is effective and that works.
This is Helen Goodman.
Thank Thank you, Mr Speaker. The Secretary of State says she wants to come up to date with what's going on now and not just look back at the tragedies of 10 years ago. Well, she needs only to look at the case of Fatima Manji to see that the same people were being complained about who were the judges and the jury in the regulator IPSO. That's the problem. Exactly.
I don't want to comment on individual cases that have been brought to any regulator. What I want to see is robust regulation.
Collins.
The Secretary of State accepts that the current status quo is not acceptable, and regardless of the outcome of her consultation, because we're yet to see the establishment of a robust, industry-funded system of arbitration which gives access to justice, one of Leveson's key recommendations.
My honourable friend, Chair of the Select Committee, makes a very good and important point, and one that I want to hear more about during the consultation.
Saville Roberts.
The Press Recognition Panel, set up, of course, in the wake of the phone hacking scandal, stated that urgent action is required if the post-Leveson system of independent regulation is to be given a chance to survive. Surely today's procrastination is tantamount to political interference by the government.
I don't accept that point. We have commenced the exemplary damages point. We now have a recognised regulator. Now is the time to take stock and look at what further work needs to be done.
Drax.
Speaker, as a former journalist for some 17 years, I was shocked when only 14 of us in this House voted against the Royal Charter all these years ago. And I questioned whether democracy was at risk. And can I remind members on the opposite side, and maybe one or two on ours, that phone hacking is already illegal and you go to jail if you commit that offence. And finally, local newspapers who had nothing to do with the scandal which occurred in a very small majority of the major newspapers, they fear that if they have to pay costs despite even winning their case, we will close down local newspapers and they will not challenge those who should be challenged.
My honourable friend again makes a very, very important point. This is why we are consulting. This is why we're taking stock.
Jones.
The Secretary of State says that press regulation is failing, but let's not forget, this government set this system up that's now failing. In fact, is it not the case that this government's been engaging in political gymnastics on this issue since the very beginning to arrive at the very point that we're at today, where Section 40 and Part 2 are going to be scrapped? It's always been the government's intention that it will pay lip service to this issue and not to the victims.
This is a full, open consultation on which no decisions have been taken.
Dr. Andrew Murrison.
Absolutely right to stand up for independent regulation and arbitration, but the consultation she has announced today will of course delay at best at Section 40. Does she not agree with me, therefore, that it would be reasonable to accept Baroness Hollis's amendments this afternoon in relation to the Investigatory Powers Bill, Clause 8?
I don't agree with that point. The Investigatory Powers Bill is a matter of national security, and nothing should get in the way of us passing that bill into an Act of Parliament to make sure that we have the right powers for our law enforcement to keep us all safe.
Slaughter.
Section 40 needs to be implemented now, not just because it's in statute and because it's a part of Leveson, because it's necessary to address what is in Part 2 of the Legal Aid Sentencing and Punishment of Offenders Act. The effect of that Act, brought in by the previous coalition government, means that it is not possible for victims to easily sue people, so they will continue to be vilified and humiliated.
I would welcome comments on that particular issue in this consultation.
Sir Gerald Howarth.
Mr. Speaker, like my right honourable friend, I too believe in a free press, but I also believe in a responsible press. And would you not agree with me that one of the great virtues of the Leveson inquiry was that it took the whole issue, this whole contentious issue, out of the hands of politicians, and that by going for this consultation, to which she will respond, she is in danger of embroiling the politicians in the issue again, and that low-cost arbitration has to be part of the solution.
I think the very fact that we are having a debate this afternoon about Section 40 tied up with the matter of national security, which is the Investigatory Powers Bill, means that we do need to take stock and work out exactly what is the best thing to do.
Yasmin Qureshi.
Thank you, Mr. Speaker. Academic research has shown conclusively that the false lies printed on a daily basis in most of our front pages of newspapers against migrant and minority communities has led to the rise of violence and prejudice towards them. And when complaints are made, all we get is a two-line correction at the back of the page, and IPSO has singled out to deal with this.
Mr. Bob Stewart. Thank you, Mr. Speaker. I'll get to it now. We all agreed in this House to unanimously agreed to support Leveson Part 1. I did. Well, most of us did. Is this consultation, therefore, simply a tactic to get the press on board?
Mr. Speaker, my honourable friend is usually at the top of my list. But I want to assure him this is an open, frank consultation where we want to hear all views so we can make a decision based on the situation we find ourselves in today to get the effective, robust regulation that we all want to see.
Betts. The Secretary of State deliberately refused to answer the very precise questions which my right honourable friend put to her from the front bench. Would she now say, having spoken to Lord Leveson, what is Lord Leveson's views about her statement today, and will she allow him to speak publicly about his views?
I apologise if the honourable gentleman doesn't think I answered the question, but to be clear, I discussed this matter with the honourable gentleman earlier. The conversation I had with Lord Leveson is a private conversation. I am not going to comment on it in public.
Matt Warman.
Mr. Speaker, I should declare that I spent 15 years as a journalist at the Telegraph. We all feel profound sympathy for the victims in this situation, but overall, is not the real prize in this that a good, free, robust, boisterous press holds the government to account at a regional level, at a local level and at a national level? And if we get that wrong by allowing it to either become unsustainable or impractically regulated, then we will lose far more than we are talking about today.
My honourable friend makes the point very well. We want to see a robust, free, strong press that does hold us to account. We won't like it when they hold us to account, but I think that they should have the right to do so.
Mr. Robert Jenrick.
Speaker, my local family-owned newspaper, the Newark Advertiser, knows what it's like to be vexatiously sued by a politician. When Harold Lasky sued the newspaper to try and ruin the local family, the Palbys, he lost. And that's now one of the leading cases in this area of law. But of course, had these rules been in place, the family would still have been ruined and my local newspaper would still have been put out of business. In this consultation, will the Secretary of State pay particular attention to local newspapers and, above all, to independent titles like mine?
I can confirm we will.
Stephen Foster.
Thank you, Mr. Speaker. I'm sure the Secretary of State, like me, will be amazed by the spectacle of a Parliament where it's the opposition demanding more restrictions on the press. But would she reassure me that we'll balance any future system against the needs of the local media, particularly in an era when sometimes update lists via email run by members of this House have a larger circulation?
My honourable friend touched on the point that my right honourable friend touched on earlier about the fact that we are in an entirely different news world than we were ever before. We have digital media, we have global players, and we have local players that can get to people through social media and through the internet in a way that is totally unregulated. We need to make sure that we look at all those issues, all those matters, and get the right regulation.
Philip Hollobone.
How many marks would she give IPSO out of 10?
I haven't yet been asked to give them a mark out of 10, so I will restrain from doing so at this stage.
Crispin Blunt.
Believing that my right honourable friend's heart is in the right place, I wonder whether the irony in her repeated statement this afternoon that it's the right thing to do for today was intended or unintended. And I wonder what assurance she could give me that she will commence Section 40 if there is no other way of getting to low-cost arbitration.
I can assure my honourable friend that I will look at all the consultation responses and I will make a decision based on the evidence.
Speaker, I misattributed a quote earlier. I was in error about which PM's promise to the Dowlers is not being kept. It's David Cameron's promise that isn't being kept, not the current Prime Minister's.
Thank you.
Right as early as I could.
Well, I'm extremely grateful to the honourable gentleman, as will the House be, and the matter is now firmly on the record.